What are we supposed to be asking Sleuthy about?
Sleuthy's got her own questions. She's going to ask Cara. We're not asking like.
Okay.
Sleuthy was working with Cara too.
Okay.
We were both trying to help her. Don't worry about it. She's got her own questions she wants to ask her.
Got it.
Okay. All right. Wait, I got to pull us all off.
Oh, people are getting angry. I'm just kidding. I haven't really read any of the stuff.
All right. What is up? Welcome to the Docket presented by Defense Stars. We're going to give you just the facts. Super excited tonight. I was able to wrangle somebody who I did not know of, I'd say about 6 days ago, and very quickly entered hero status in my world in the blink of an eye. I'm super excited that she was willing to come on with us and let us talk to her about the amazing filing that took place. I mean, kind of what's going on in this case. And we're obviously talking about Richard Allen's case, Delphi, is unbelievable. To me, it's unprecedented. I've seen a lot. I've seen a lot in the law. With Allison and I have been a part of some pretty crazy cases ourselves, but this one is next level. So without further ado, I'm going to bring her on, or maybe I should do her bio a little bit. So Cara Wieneke, Indiana attorney who went to IU, I believe, for undergrad, got her, I think she also got her master's there. I think then she went to law school, got her law degree at IU, I think at the Indy campus. She's been practicing for over 15 years. She's licensed, does primarily post-conviction work. So we're talking after somebody's convicted, she handles appeals, post-conviction relief act petitions, and she obviously argues up at the Indiana Supreme Court. And I also saw that she is licensed to argue at the Supreme Court, the United States Supreme Court, which is super cool. So I'm going to ask her if she's been lucky enough to get up in there. But without further ado, let's bring her on. Welcome, Cara. How are you? So we're super excited to have you. And our other guest, my left-hand woman, the woman who does all my digging for me, and that is Sleuthy. What's up, Sleuthy?
Does my mic work?
It does work.
It does.
Oh, thank God. I'll say hi to Allie. You forgot to introduce her, Bob.
I did introduce her. I said Allie, Cara. And of course,
hi, Cara.
And my beautiful co-host, my brilliant, beautiful wife, Allie. Welcome. Hi, how are you? All right. So, I mean, I've got a million questions. I think how we're going to kind of handle this. And I'm just going to go ahead and throw the document up. Hopefully it doesn't block all our faces.
And then I've got a great first question that I think will help that all our listeners would appreciate.
Start.
So can you start and just explain to us how one comes to be a realtor, or how it works when you file a writ of mandamus, maybe as compared to like your typical action and relationship with the plaintiff or the defendant?
So in Indiana, an original action is different from like an appeal, because your argument is either that the judge has not done something that she must absolutely do, or in this case, we argue the judge has done something she's not allowed to do. We call it outside her jurisdiction to do so. So she's acted in a way she doesn't have the power to do. So that's what kind of makes it an original action, which makes it a little different. On our first one, the relator, that's how I say it, could be anybody, because it was like a John Q. Public situation, right? Anybody has, the right to access to the docket. In the second one, obviously, Mr. Allen was the obvious one, because he was the person injured. So.
Correct. And the relief that you sought. So in the second one, is that where, does Richard Allen need to say, hey, Cara, hey, lawyers, I want you to do this thing for me?
Yes, and it's kind of tricky because he's not easy to get in touch with. And so, and obviously his old lawyers, the ones we're trying to get back on, can't talk to him now because they've been removed, and there's kind of a, you don't want to get in the way of the new lawyers. So yeah, we had to be kind of creative to be able to get to him and make sure he was okay with this. But he's doing as well as he can, and he's okay with it. So
then basically, as far as when you're doing like a hey Joe Public type of thing, ask the judge to just do something the judge should do, such as filing. In that situation, you can file it, and you don't have to have any relationship with the defendant or the party in the actual case.
Right.
And in the second one, where you actually, ask for relief on his behalf, like, have the trial stayed until this is decided, have this done. Obviously, in those types of situations, then, as you mentioned, you needed to have the relationship with the actual party.
Because in the first one, we could have just pulled anybody we wanted to and used them, but we still wanted to use Mr. Allen because ultimately, he's the one that has the right to a public trial, and it was his case that we were talking about, not being fair. I understand a lot of people think, oh, you're litigating this in the court of public opinion. Well, not really. I mean, public trial, that's a very basic fundamental right we have. And part of that is access to the court. And so that was our argument.
I feel like anybody saying that is like not happy with what you're saying because it's true. Like, we should know what's going on. I feel like we should know. Like, I make it my business to know what's going on.
And it's not like we haven't had high profile cases. I mean, we had Mike Tyson's rape trial. Some of you might be too young to remember that, but we had Mike Tyson's rape trial. We've had other high profile cases in Indiana. So it's not like we don't know how to handle them. But yeah, some things get out. Some people are going to follow a case, that doesn't mean those people are going to be on the jury. In fact, those people probably aren't, because if they're doing their job, the attorneys, they're going to take anybody who knows a lot about the case right off the jury. So
Cara, and kind of when I reached out to you after the initial petition dropped, I was super excited about it. I definitely called you and Maggie. I'm not sure if I called Jesse. Jesse's the other lawyer, correct?
Right.
So I definitely left messages for both of you. I'm like, oh man, I really want to talk to you guys. I'm so excited about this. So what kind of drove you? And one of the things when you had gotten back to me, and you got back to me pretty quickly, in respect to, you're like, I hadn't really been like diving into this case all that much until things started going awry. And like, what was kind of the impetus for you in terms of saying, you know what, I've got to intervene here. I've got to get involved. Did like Brad or Andy call you, or did you what brought you in?
It was, so the Frank's memo situation happened, and I don't know if you remember, they filed it public. Somebody pulled it off pretty quick. Like somebody was able to download it. And then they pulled it, somebody at the court pulled it off pretty quickly. But by that point, it had already been around. And I was like, this is so crazy that this is not up on the internet. And not only was it not up on the docket, but it was completely removed. Like it hadn't even been filed. And in Indiana, that's just, that there's no precedent for that. Like, even if you make a clerical error on the docket, there's the clerical error on the docket. You know what I mean?
Right.
And so that kind of made me wonder. I reached out to Maggie privately. I'm like, this seems odd. But we sort of, okay, maybe if the media isn't making a big deal about it, everybody has it anyway. And then the removal of the clerical filings at the end with the motion to disqualify that Brad had filed. At that point, that was like, you can't remove documents that filed. Even if something's filed in error into a case, it still remains on the docket. And so at that point, I reached back out to Maggie. I'm like, have you seen this? And she was like, maybe we just need to do something. And so we are the ones who actually reached out to Brad and Andy. Are like, what's going on? What is happening here? We were already paying attention because it was unheard of that they were withdrawing, because I watched on court TV or whatever. And I was like, oh my gosh, what happened? And so I was thinking, I thought, maybe they got threatened, their lives from somebody or something had happened. And so I was like, okay, this is interesting. But when we saw the filings from Brad, we were like, oh. And then at that point, we thought, all right, it's time to, do something.
So let me ask you, I'm sorry, babe, are you going to?
No, go ahead.
Or Sleuthy, if you had something ready, go.
She's just so awesome. I was just sitting here thinking, like, whenever you were like, it was when she put in that order to remove, his pleading to stay and all that. It was like 3 or 4 different things. I was like, can she get rid of these just because she doesn't like them? Like, it felt very retaliatory. Like, well, I don't like what you wrote in there, and I already said that you were gone. So now not only am I going to reiterate that you're gone, but I'm going to remove it so that people can pretend like you never wrote them. And that just seems really, that was why I messaged you that one day. And I was like, does your docket look the same as my docket? Because I'm just wondering how many things exactly have been removed because they don't look good, as opposed to just made confidential, which we know she does constantly.
What's interesting is that we have 3 levels, I think, of locking. We're not even really sure, but the public can't get access to everything online. So that's your level. Like, there's some stuff you just can't click on. And then attorneys can get more stuff. Pretty much anything publicly available in any case they can get. But we couldn't get those, which is interesting. That means they're literally locked confidential.
But for everyone, they're visible.
Yes, and they should, that should be okay too. That's the whole point of the way that our rules are set up. If you're going to make something confidential, fine, but you have to file some sort of a notice to let everybody in the world know, hey, I've made this confidential. It's a mental health record, it's a medical record, whatever. You cite on the notice why it's confidential. Now, maybe a judge doesn't have to do that necessarily, but they have to there has to be a reason under our rules why it is confidential. And so even when you're the judge could probably strike the motions, meaning I'm not going to consider them filed. I'll simply receive them, I guess. They can do that at times, but to actually tell the clerk remove them, that was something we had not seen before.
And that kind of leads into the question I was going to ask you, and you kind of just might have answered it. As far as things in Indiana on the docket, when you're looking as counsel or otherwise, if something is confidential, like, an evaluation, mental health evaluation, like you said, or any number of things that sometimes are literally confidential, do you typically see that form that you're speaking of actually on there as typically?
Yeah, I would see it most of the time because you have to file it. It's a rule. If you don't file it, technically the clerk is supposed to reject it and make you file it. And it's pretty, it can be pretty serious if you're not filing it, or if you're putting something confidential up publicly, that's not good either. But to see it be the opposite, where things that I thought would be pretty routine not being allowed to be, read by the public is very different. Yeah.
And none of the filings that had been removed, whatever you want to label them, there was none of the corresponding, what's that form called?
I used to call it an admin rule 9 form, but they took all the rules out of that administrative rule, moved them and made them their own. So I think it's called a notice of exclusion of confidential information. Here's the other thing. If you're going to exclude one document in a case because it's confidential, if there is a way for you to be able to redact the information, you just like we saw with the probable cause affidavit in this case, you can redact and then that part's public and then you have a confidential version of as well.
So essentially they're supposed to try to not make it confidential. They're supposed to put out like a public copy and then the private copy. I know that in Idaho, what he does is when they released like the search warrants and stuff, once they were returned, because in Idaho, that's a public record once it's been returned.
Right.
And I guess because I requested it because I had another lawyer, an appellate lawyer in Washington that was like, you could get those as long as they were served. And as soon as I asked, it was like the next day that they started putting them on the docket and sealing them all. And with each one, it lists like pursuant to A, B, and C. These are sealed, but it would mainly be like the affidavit to get it. Like it wasn't the actual warrant itself that was redacted. And then the return was redacted, but for each and every one, there's hundreds of them. They all had reasons. Some of them were copy and paste, but all of them had reasons why they were sealed.
Yeah. And that's how it's supposed to, at least they're supposed to tell you why it's sealed so that as the public, they know why they aren't entitled to have access to it. Yeah. And you usually have to generally say what it is. So mental health record or medical record or something, you have to give some sort of notice, at least so that the public knows what was filed. They can't read it, but they'll at least know. Because you see what happens whenever you don't do this. I mean, this case is nothing but distrust and conspiracy theories everywhere. And that's what happens. People will start to question the system. And obviously we don't want that, So.
Babe, do you have any questions? Go ahead. Sorry.
No, go ahead.
I was just going to say,
saying if she's not like sketchy, then she could not have picked a more sketchy thing to do when everybody was already kind of on edge about what was going on here.
It's just, I think that our Supreme Court sets out these rules so that's not something that they have to work. Judges just follow those rules. Then everybody kind of knows what's, why things are taken off and they don't have to wonder about it. And so, now I think with these two filings, most of what it was in the docket is now out there. That's public. There were only a couple of things we couldn't get access to still, but they weren't that important to get. So.
Yeah. And when you guys drafted the first petition and like, I think that's when I hit you up and you were like, well, like, I have to tell you, like I was an assist on this one. That was all Maggie in terms of her just incredible knowledge of those particular rules with, respect to the public records, court records. And it laid it out so beautifully, it's like I was able to read it and know exactly what I was looking at in terms of what she didn't do, because, Alice and I have been practicing a long time in our dockets, in terms of our cases, we don't leave a courtroom without a written order in a criminal case ever. I mean, there's still some counties that we go in where they're handwritten still. The clerk gets them, the judge signs it. They give us our copies, and then later they enter it into the docket. But I leave with the paper copy. You know what I mean? So when I started following the docket after the arrest, and there's just these gaping holes where I'm like, what in the hell is going on here? I was lost. I didn't know what she was doing, because when she originally was appointed, after Diener had recused himself, I looked her up. I'm like, all right, she seems like she's the type of judge that can handle a case like this. As at least the three lawyers in the room here, we've all been in front of judges where, they may have been a little bit over their skis in terms of what they were dealing with. We originally had one of those judges, in my estimation, on the Garcia case in Omaha, Nebraska, and we were out of towners, you know, so they hated us. You know what I mean? They really, really hated us there. And, you know, they saw us as the big city lawyers, not realizing that we live in rural Illinois, kind of 45 minutes out of the city. But for them, we're Chicago lawyers. And, you know, just the judge that we had handling that case was not prepared. He had never handled a case of that magnitude. I don't know that he'd ever handled a murder, let alone a quadruple homicide that spanned years and that was going to be a death penalty case and was going to be heavy duty litigation, you know. And so when I originally saw her, you know, I was like, oh, like I'm happy about this. It looks like it was the right choice. And then the case started in earnest. And you know, really when they tried to move, when Brad and Andy tried to move Rick the first time, try to get him out of Westville. And again, but leading into that, there had been some inconsistencies with the filings in that they had filed a motion to let bail where, you know, they were basically saying, look, we don't think that there's enough evidence that he should be held without bail. Like we're looking at the same PCA that you are, and it's deficient and they have to have more. And I was so excited about that. I kept telling everybody, I'm like, this is going to be like a mini trial. The state's going to have to produce more, because when I read that PCA, it was thin. And that's still my feeling on it. It's a very thin PCA. It's mere presence. It's an uncased, or a unspent casing. And, you know, I'm like, there's 4 people that give 4 different identifications of a person on the bridge. And the mere presence is Rick Allen volunteering the information to them. You know, people are always saying he admitted he was there. I take exception to the word admitted, just because that always has a connotation of guilt. Like, I've admitted that I've done something wrong. He volunteered the fact that he was there because they were asking everybody who was out there to let them know and let them know what they observed. So, you know, going into that particular hearing, I'm like, man, we're going to really hear it all. Like, if they have more, if they've got more post arrest, we're going to hear about it. They're going to have to beef it up a little bit. I think otherwise maybe the judge is going to, you know, set bail, and then that changes like kind of overnight, and they change it to like a very bare bones suppression motion. So I'm heading there, driving to Delphi, thinking I'm going to be hearing some kind of suppression motion. Not exactly sure what it is, because it was a very bare bones filing by Brad and Andy, and I think that was done strategically in retrospect. But then I get there, and it turns out that, you know, they filed the motion for the transfer to get him out, and so that's what that hearing ended up being. But again, it goes back to the record. It goes back to the docket. None of that was indicated on the docket going in. It was like every time I've driven out to Delphi, it's been like a surprise party. Like I haven't known what is going to be. Like Alice will be like, "Oh, what are they doing?" I'm like, I don't really know. It's like they, you know. And when we get into the month of September with the, you know, the bombshell 136-page memo in the Franks hearing, and that thing drops. You know, and like, I think I did a Twitter Spaces where I read the 25-page introduction, and I was just like, I was losing my mind. I mean, I've been practicing for 20 plus years, and I'd never seen anything like it.
Same.
You could hear him shaking.
Oh man, it was. I was blown away by it. You know, and like you said, like Allison had emailed the clerk right away when we found out that it had dropped, and one of the clerks emailed it to us. So we had gotten it from the clerk before Gull sealed it or whatever she did with it, where she took it off the docket. So like at that point we had it in our hands, and we're like, oh man, this is unbelievable, you know. But at that point, I think she had made the ruling denying the move from Westville to Cass, and you know, and Cass was clearly suitable for him. You know, I think the sheriff testified. He's like, well, we don't want him, but we could handle him. You know, and I'm like, I left the courthouse that day thinking, okay, well, she's going to move them. I'm like, no matter what, they had to know that the warden that got up there from Westville, that they probably weren't being completely honest about things, just because I just don't think they were. I mean, I've dealt with our clients in jail. I know what goes on with these guys, these pretrial detainees, where you have, children that have been killed. There is no presumption of innocence in jail pretrial for these guys. That they're viewed as monsters immediately by the guards, by the inmates. It's a dangerous situation in general. So I was hoping that they were going to get him out of there, and I thought that she would do that. When she didn't, that was the point in which I began to lose faith in her, because I didn't understand the move. Because she had originally ruled, and it had gone unopposed in terms of the change of venue or change of veneer, however you want to term it. And she ruled, that she granted, so to speak. It was that was also weird. It wasn't like a traditional I'm granting the motion. It was kind of like it was a beat around the bush type of thing, where she just said, I'm going to import a jury from Allen County, as opposed to saying I'm granting the motion. Like the press was asking me when they came out, and I'm like, did she grant the motion? And I'm like, I think she did. She said she's going to import the jury from Allen County, but she didn't say I'm granting the motion. And I think if you look at her minute orders, which there's a fellow subscriber to the show, I think he's a subscriber, but his name is Travis. We were talking about it last night. She does a lot of minute orders, which just means that basically the clerk is typing it in. Is that normal there?
It can be, yeah, sort of a shortened way of doing it. And I assume that this case is bigger than normal, in that they probably had more telephone conferences with the judge. And so I know sometimes things were set in the telephone conference and it may not have made it onto the docket. My guess is part of that could be because technically it's the Carroll County clerk that's doing all this, and Judge Gull is away from the Carroll County clerk. So there's got to be a lot of communication going on.
When you see things like, because in what I'm used to is like, if the judge enters a minute, entry, there's still a corresponding like regular court order from that day. Are you saying that sometimes in Indiana, the minute entry is the only?
Sometimes there is, yep. And it goes out to the attorney. There should be a notice provision that'll notify you, and it's just as good as an order usually.
So let me ask you this then. Because one thing we thought was very strange, because I'm assuming that most of the orders, when they're entered, or even the minute entry, and this notice goes out, is it typically the same day that it is entered?
No, it doesn't have to be. So they'll have like the date that it's on the docket on the left-hand side. If I understand correctly, that's the date it's actually entered. But the judge, like in the 19th order, the October 19th, she technically signed it on the 19th, according to her order, but it didn't make it up there till I can't remember when it made it up. That's not unusual. Most judges are, they're pretty good about getting their orders up quickly, but in some cases, it all depends on how quickly. Like sometimes some of the parties will write the orders for the judge, and if it takes a while for the order to get there, it may be a few days before it's on the docket.
So you're saying it's also not unusual that she would say she signed it on the 19th, but the notice would have been so late after the fact, as far as when she sent it.
That's not that unusual, no. Unfortunately, in some of our CPS or DCS, we call them, cases, you might be waiting a month for the order to hit the docket.
See, but the problem with this case is the timing of it all. In terms of the appearance of impropriety, in the sense that as soon as Brad filed his verified statement that he still considered himself to be counsel for Richard Allen, and then also filed the motion to DQ her, immediately, I thought immediately that she backdated the order, because then all of a sudden the order shows up after he files these things. So, and I think that that's just going to be the problem in terms of when this case is getting looked at, whether, no matter how it plays out, if it plays out that our boys aren't reinstated to the case, and God forbid he has to go to to trial with Libredo and Scremin. And Scremin might be a fine attorney. I don't really know. Libredo, I have serious dire concerns about in terms of him handling this case, based on the research that I've done. But, you know, if he goes up and gets convicted, and when the appellate court has to start looking at this record, you know, the fact that she did that, even if it's the norm, just in the way that this all played out, which is leading us into that conversation where you had asked and requested the transcript.
Well,
Brad had requested the transcript of what happened on the 19th, and that becomes so imperative. But I don't even want to jump there yet. All right, so I tried to make a new thing here. So I'm going to see.
Can I respond to that real quick, though?
Of course, yes.
Here's the deal, though. To me, the written order isn't that big of a deal because she said it in open court. And so at least in Indiana, you know, that was the ruling from the bench. Her written order was just sort of the follow-up. I didn't see anything. I didn't see any problem with that. I assumed, benefit of the doubt, probably it just took a minute for the clerk to put it up. But again, I'm not a member of the public necessarily. I deal with so I see why people were.
Smoothie's all covered, babe.
I know. I'm doing my best.
So I see why it looks good to me. I don't know,
probably because I mean, that was probably a good time to do it too, because my face was like, but what, so we're talking about the one to allow them to withdraw? Because where I get confused is she was waiting on his withdrawal. So it's not like when she was on the bench, she wasn't saying, you know, he's withdrawn. She's saying he's going to file it, I guess, in the next couple of days.
And you know what? That may have also been, well, here's the thing though. She signed the order on the 19th, according to the order. And so I don't have any reason to dispute she did that. And she had made the order from the bench. And so I was kind of like, you know, I don't know, the written order wasn't such a big deal, but I see because of that delay in the timing, you can see it can breed questions about whether or not something's going on. And so, you know, I see that. I hadn't thought about, though, if she was waiting on Brad to file a motion. Yeah. I hadn't thought about that.
Yeah.
Well, right. That was the entire point, because the conversation that had taken place with respect to what happened in chambers is that Brad had said, look, I'm not going to make an oral motion to withdraw. I want to put it in writing. And, you know, and we know now, because you were able to get the transcript in terms of what happened that day. You know, Brad said, look, that was strategic. You know, I wasn't going to let you torpedo my client's case, you know, by forcing the hearing to take place. So strategically, I had to put you off, you know, and it was a great move from his perspective, because it achieved what he needed it to achieve, which was to buy him time in order to figure out what was going on. Because, you know, the whole conversation of you know, the ambush, and, you know, there's the other side of this who I'm debating constantly. You know, I'm like, look, this isn't an ambush in the general sense of the word. This is a legal ambush in that there was no notice. There was no pending motion, either sua sponte or by the state, for disqualification. And, you know, and Rick Allen wasn't there. Like Rick Allen was never brought into, like, you cannot conduct these things without the defendant being present that are going to affect his rights so massively. You know, everything about it stunk, you know? So, like, I got why he did it. I just think when it gets down to the point where if an appellate court is looking at this down the road, it's going to be sticky, you know? So hopefully it's avoided.
I want to ask, because I think people are viewing that ambush totally differently. So when one's thinking of ambush, they're saying, well, their choices were that they could either, you know, withdraw, or they could go out into open court and she would, you know, tell them what they did wrong, what she found was grossly negligent, and then they could defend themselves. That's not how I'm understanding it. How I'm understanding it is the choices, the only two choices, where you either withdraw back here and you don't go out there at all, where you do go out there, I read my bullet point list, and then we go into recess. Like, you don't get to argue that you didn't do these things. I'm just going to put on the record and let everyone know that you did. Right?
Well, I think that.
Well, does Cara know any
Well,
more?
I was there.
Not more than you do, no.
I was there. So so she had, and whether it was her or McClelland, I don't know, but somebody had arranged for 9 cops to be there. They were all sitting in the jury box. 2 days prior to the hearing, she had approved cameras for the first time in the case in the courtroom. She had set it up for the ambush. Okay. So everything was in place.
No, but Sleuthie's question, and I don't know, maybe it was addressed in.
I think she was going to conduct a hearing and she was going to put those witnesses on. Now, whether I think she would have had to have given them the opportunity to be able to put something up. The problem is they didn't give him any notice, which is what Dave Hennessy, when he stepped up on the 31st and got into the well of the court and made a record, that's what he said. He's like, look, I would have had X, Y, and Z all here to appear to testify on behalf of the defendants and the defense. And, you didn't allow that to happen because there was no notice. So, yeah, I think that her plan was, well, that's what I'm saying, that but the other argument is.
Wait. So let's just flesh this out for everyone. It sounds like what you're saying is you understand the ambush to mean she was going to allow a hearing per se, but only with the witnesses that she had ready to go because the defense never had an opportunity to even bring a witness in.
Correct.
So they would have just been standing there saying, no, we didn't. No, we didn't. And then
Correct.
That would have looked bad anyway. So.
And they would have put the parade of cops up there, testifying about their investigation. The very cops that have a vested interest in conviction on this case are the ones who did the investigation into the,
So you're saying those cops, the officers that were there on the leak? Is that the testimony they were? Okay.
100%.
And is this an assumption, or this is an assumption, or this is based on?
It's I'm going to call it an educated guess, because what we know was not happening. The only reason that they could have been there, and it wouldn't have been 9 of them, would have been for the Franks hearing, and that would have been Liggett.
Well, it was people that they were accused of lying. I mean, those people were there.
Right.
Yeah. Now this was 9 cops all in the jury box. This was not. It could only have been. That's what I'm saying. There were 2 pending motions. There was a ballistics, a motion in limine to keep the ballistics out, and then there was the Franks. Those were the only 2 pending motions. The motion to suppress / Franks motion, and that was it. And we know for a fact that she hadn't even made the preliminary finding on the Franks in order to get to a Franks hearing. So it definitely wasn't going to be the Franks hearing. It was a show of force. And I can't wait till we get the transcript, because it's going to lay out exactly what she said to them. It was a veiled threat. It was a Hobson's choice. Everything that Brad said about what went back there is exactly what happened. I have no doubt about it. Like her slow playing this thing, if it exists. And that's the one thing that I was going to ask. What do you think of the odds that it would be stunning to me if she lied about the fact that it was recorded and it wasn't?
Well, so let's start.
No,
before we let Cara answer that, let's let's not assume that everyone listening and watching knows everything. So Cara, is part of your motion dealing with the fact that there was certain events that happened in court for which you could not access a transcript, and was part of it dealing with what findings the judge made to disqualify? And can you speak to whether or not you have had access to those transcripts and what is being done about that?
So that we were given access to all the transcripts, but the in-chambers hearing. And I did not talk to the judge about this. It's only the court reporter that was responsible for it. So I don't know if the judge said this or not. I know someone had shared that they contacted the judge separately and actually was able to get a response from the judge.
That's Sleepy and Bob. Yep.
Yeah. The court reporter told me that it is confidential and that we were not entitled to it. So I entered my limited appearance, which should make me be able to get, anything confidential too. And I was told then that they just weren't going to give it to me. That was the policy until a court ordered her to produce it. She wasn't going to do it. And by her, I mean the court reporter. And so we had to go based on the attorney's recollection, which, you know, it's not going to be perfect, I would assume, but probably pretty close. I don't think anybody's disputing. Our position is our second action. Let's pretend that full-blown hearing had happened on the 19th, and Mr. McClellan called 9 witnesses and proved up literally every bad thing that has been said. Would that be enough to disqualify them? Our position is no. In Indiana, there are only 2 times you can disqualify an attorney, and it doesn't matter if it's a public defender or a private attorney. 2 times. It's an actual conflict of interest that's not waivable, or it's if they're not a member of the bar. We couldn't find any other situations in Indiana and in a lot of other states where you could remove an attorney for any other reason. And so that, to me, it's clear cut. We sort of accepted all of the worst things that could be said about trial counsel. And the leak, they took full responsibility, you know, everything like that. And we said, even with all of that, we just don't think that it's enough that you can remove them, particularly where Mr. Allen has been, you know, unequivocal. He wanted them. He's said that in many different ways, many different forms. And to me, in my opinion, that's one of the biggest reasons why they shouldn't have been removed. Even if they're doing a terrible job, if everybody thinks, oh, this is awful, those are his lawyers. They were appointed. He likes them. That's who he wants to represent him. That's one of the most basic rights we have. So that was sort of our position.
And then with regard to, and again, we're talking about the transcript and or the recording of this in chambers discussion wherein the judge gives them what Bob's calling the Hobson choice and lays out what Sleuthie's calling the ambush, and makes her findings of gross negligence. Has the Supreme Court taken any action in regards to your demand for that material?
Yeah, so just today they entered an order that gives that tells the Judge Gull and the Carroll Circuit Court that they must either respond to our motion for a transcript, because we filed a motion for transcript in the Supreme Court. They must either respond to that, or they must produce the transcript in their record that they can supplement the record with. There may be things that she's going to add to the record to help, you know, resolve these issues. And one of them could be that transcript. So we just have to wait and see.
And so circling back to, like, I think Sleuthie's also initial question, I think you've sort of answered it, but just to be clear, based on the response you got from the clerk and the response Bob and Sleuthie got from the judge, it's your understanding that there is an actual recording.
We've had several people ask in various ways, and we're assured that there is a recording. Brad remembers asking for the court reporter to record. He remembers her coming in and sitting in the chambers and hitting the button. So we're pretty sure there's a recording. Yeah.
Okay. And I know one thing that everybody wants to know is sort of how quickly these things happen. So, for example, did the judge, was there a deadline the Supreme Court gave Gull to either produce the transcript / recording or respond to your motion for same?
Yeah, right now, the response deadline is November 16th, so next week, and that's for both original actions. She has to respond in both of them at the same time. And so after that, I don't know. Our Supreme Court does not like original actions. They're disfavored. People file them, but I don't know that they've ever granted them in a long time. So it's a very, very rare remedy. I think we fit it. I think it's, you know, it's one of those cases where we might be able to get it heard and maybe even granted, but I don't know. They could take a month. They could take longer. It's really up to them.
So
let me jump in real quick, Allie. Would they rule on anything piecemeal? Like, say for like to me, the fact it's very disconcerting that the trial court can continue to operate while this is pending. I mean, is it possible for them to say, okay, well, we're going to rule on the issue of the stay. We're going to stay the trial court, meaning delay it for those of you out there that don't know, and then say that we're still addressing the rest of it. Is that a possibility?
They can do that. We actually filed a request for an emergency writ to do that, to sort of freeze everything in the trial court. It's hard because in this case, his strategy is to go to trial. So, there's a part where you're kind of like, do I want them to stop everything? At the same time, though, we didn't want any steps to be taken that would somehow undo some of the things he's already done to work his strategy and his defense. So we did ask for that. Yeah. They could do it piecemeal if they wanted to. Yeah.
So it seemed to me I was under the impression, based on you saying the Supreme Court says, produce the transcript / recording or respond to that portion of the motion, that I took that to mean they were kind of addressing that in piecemeal. Is that not the way it is?
I imagine that they are. And I imagine that they would like to see the transcript too, because it is relevant, right? It's at least relevant to see the full picture as to what happened. And, I disagree that it's confidential. I looked really hard at the rules. I just don't see it falling in any one of those where it is confidential. So, I feel pretty confident that we'll end up getting the transcript.
I'll got one more question, and then I'll turn it over to Sleuthie or Bob, and then we definitely have to address some questions that we've gotten from people that are directed directly to Cara. But based on what you said about the Indiana Supreme Court not really liking original actions, not necessarily addressing them promptly, or whatever the case may be, do you think it may be in Richard Allen's best interest that he asked his lawyers, his new public defenders, to file an interlocutory appeal as to his rights to his counsel of choice and or continuing counsel of choice?
And Allie, what is an interlocutory appeal before we...
Well, we'll let Cara tell them.
Cara, explain to the kids what an interlocutory appeal is.
So an interlocutory appeal is an appeal of an order that's intermediate. It's not a final order, so it happens in the middle of the case. In Indiana, here's the trick with it. In order to get an interlocutory appeal, you have to get permission from 2 different courts. First, you have to get permission from the trial court you're in front of. And there's a problem with that. In this case, why we thought the original action was the route we needed to go. Number one, we didn't think we would get permission to do an interlocutory appeal. And number two, the timing, because then you go up to the Court of Appeals and it's not the same sense of urgency. They don't do original action. So they're going to treat it like other appeals would be. It would be given priority, but it's still going to take time for it to work through that system.
So you don't have a process. So in Illinois, for example, we have, you can't do a criminal interlocutory appeal unless you're the state and they're excluding evidence, or you're the defense and they have removed or disqualified your counsel of choice. And any interlocutory appeal on a death case, on a capital case, goes directly to the Supreme Court. It sounds like what you're saying is that is not the case in Indiana.
No, we have some interlocutory appeals as of right that you can take. You don't have to get permission, but most of ours, and this one would fall under a discretionary. You've got to get permission from first the trial court and then from the Court of Appeals. And
so what does the defendant have as of right? What is the one that the defendant has as of a right?
If he's denied bail, I believe that altogether that is an as of right.
Yeah, we've got that too.
The state, I believe, gets one if a suppression hearing is granted and they can't really proceed forward.
Yeah.
Off the top of my head, those are the 2 big ones I can think of in criminal. They're rare.
Yeah. So I'm just surprised that one's not an as of right one. And that now explains to me why there has not yet been an interlocutory.
I think we can count on our one hand how many times I've heard of counsel being disqualified. And our research revealed, I've never heard of it myself. I think we found a couple of cases where a long time ago, different set of facts. So
based on your experience and what you're telling us today, you don't have a lot of faith that this is going to be something that this court takes up very quickly, very efficiently, and firmly, necessarily.
Oh, I think they will. I think they'll be quick about it, because I do think that we're unlike other original actions, and that, you know, time is of the essence. We tried to make that clear that, you know, I think that there's probably going to be a delay in his trial, even if he gets everything he wants, just because of the timing of all of this. But you know, it won't be October. And so we thought, well, you know what, we've got to ask for what he wants. What we're most worried about, obviously, is any of this disrupting what he's put forward. When you're looking from the outside, I didn't know that they had a defense. I didn't know that they had this speedy trial strategy. You know, the Franks memo kind of let you know there is a defense. And then I didn't know why. I would have never thought in a million years they were going to be ready to go to trial in January. Who would?
Me either. And let me jump in real quick, because like that stunned me. Like I was publicly saying there's no way they're going to trial in January. You know, I mean, like there appeared to be so much that had to be done pre-trial still. I mean, Gull had not set dates for any of the hearings, for anything that had been filed. And she said on the record, and I can't wait to get the record, because she admitted not only to not having gone through the exhibits that were attached to the Franks memo, but that she hadn't finished reading the memo itself. She said both things. Like, it's only getting reported that she said she didn't get through the exhibits. But to me, a month out from when that thing was filed and she still hasn't read it is very telling, you know, because like for the purposes of Rick Allen now, okay, and once it came out that they were actually, you know, because again, the other side is all saying that this speedy demand was all bluster, that they weren't going to actually do it. And we all know, I mean, they can make the speedy demand and then a week before trial say we're waiving it, you know, and then the thing gets continued. I mean, that's a possibility, you know, but I'm going to assume that they are ready to go to trial. I think that their feeling was that McClellan was not ready to go to trial. I think that they thought that they would go in there and hand him his ass like that. That's how I feel about it, because I don't think that the state's case is ready, or that their case is as weak as it appears on paper without me having the benefit of knowing what else they've been able to come up with in terms of evidence. But my bigger question is now that this has happened, now that it's been put on the record that it was his intent to file a speedy demand, and that it was going to be filed in early November, and that's of record at this point. So Brad said it in open court on the record. And now what we have here, so there's a speedy demand that was going to be made, which means that trial was going to have to happen on January 8th. And now we have a situation where the judges removed counsel, okay, and put two new guys in. So they've eviscerated his ability to have a speedy trial. This move in and of itself, as an appellate attorney, do you think that has legs?
Not in Indiana that much, and I'll tell you why. This happens with frequency, that a client will first get charged and he'll say, I want my speedy trial. And the attorney will not be ready to go because he just got the file, and he'll say, look, I can get you there in 70 days, but I may not be as prepared as if I have more time. Generally, it's, yes, the right is the defendant's, but a lot of times we will, when you look at opinions that have decided this issue, they've often said, in a way, it's the defense counsel's decision if they want to waive that, you know. And I say that because it's kind of loosey-goosey, but the reason I think that they had this strategy, even more so than just trying to sort of catch the state, you know, not prepared too, is, I mean, you know, Rick Allen's in horrible conditions. He's not handling it well, at least not physically. I mean, everybody could see the toll it's taken. And, you know, he'd asked many times to be moved, and those were all rejected. He's in the exact same spot. I mean, this was the only way to get him to a different, even if he's convicted, he's not going to stay where he's at probably. So, you know, the only way to relieve that is to get to trial and get it over with.
I mean, what about like what we had to do, because we had a very similar circumstance with our client in Omaha, where same thing. He was in SEG 23 hours a day, you know, and he was literally losing his mind. I mean, so we had motioned the court to get him out of there as well. and to change, like we knew something was going on, but we couldn't know exactly what because of the fact that he's in the county jail and they're not going to tell us. You know, they're certainly not going to admit to doing anything untoward or that it was torturous. So we ended up challenging his competency just to get him out to the Lincoln Medical Center. You know, that ended up being our move. And I mean, it was legitimate. I mean, at that point in time, he was not able to assist in his own defense, you know, because he had lost it. Like they were torturing him in the sense, not physically, but just doing all the things that they do to these guys in there where they don't let them sleep. They just do and say horrible things. You know, they keep the lights on, they wake him up all night. He can't get a good night's sleep. You know, he's not eating properly, everything that goes along with it. You know, I mean, that could have been a move. You know, I guess I didn't really think of it. I'd hate to think that they were rushing it to trial in order just to get him moved. You know what I mean? But I mean, it could be legitimate though.
Well, and to stop the deterioration of his mental health, assuming that means they are also ready.
Right.
They wouldn't have done it if they weren't ready. And then, so I was going to ask another question, but I'm not going to because we've got so many members and super chat questions. But before we go to them, Sleuthy, what do you have? If anything else additional?
Not really. I'm just listening. I like to hear her talk. I'm just sitting here. I'm sitting here wondering, like, there's a million things going through my head. Like, number one, like, if the judge, if McClelland, if the jail itself, no one has an issue. And I know Teresa has brought this up multiple times. If nobody has an issue with him being moved, I'm not understanding why he's not being moved. Number one. I do think that they were ready to go to trial in January. I think they knew that where we were at once that motion came through was they started re-interviewing people after the depositions and stuff. I think it was a good time. And I think that's exactly why all of this has happened. I don't see, even if they let these men go back in and represent him, I don't see how this could possibly go forward with her still being the judge. So what happens if they do reinstate these attorneys, but the judge stays?
Well, that's a good question. My guess is the attorneys, if Andy and Brad are put back on, my guess is they will file a motion to recuse and there will be a full-blown recusal hearing. Our position was that even if you reinstated Brad and Andy and left the judge the same, the problem is that doesn't cure the prejudice to Rick, because now he has, let's assume that's what happens. And then let's assume that they go to the motion in limine on ballistics, right? They decide to hear that. And the judge hears it and she denies the motion and allows the state to go forward with this. What is the public going to think?
Right.
They're going to think she's denying it because she must not like the attorneys, right? And that is not the position that you want to be in if you are the judge or anybody else. You don't want to have that distrust. And that was sort of our argument.
And it's a great argument. And it's true. I mean, she's on the record as saying that she thinks that they were grossly negligent in the representation of Richard Allen. You can't unring that bell. It's out there, you know, it's out there in the ether, and it's never going to go away. So, you know, I mean, it seems to me that if they're going to reinstate them, and I know that we're not allowed to really put odds on it, but like you said, it's a very rare, it is an extraordinary remedy. It really is. So, I mean, like in terms of your confidence, instead of us putting a number on it, how confident are you? Would you say you're extremely confident, moderately confident, not confident, or not
too many
at all?
That's too many.
I wanted to give her a range. I
am an appellate attorney and I do post-conviction work, which you know is even worse than appeals in terms of winning. And I represent the defense. I never win. It's unheard of. So I always go in with, we try, we do our best, we see what happens. I can't be confident about anything, honestly, because I really don't know how the justices see it compared to what I see. So I feel better than the last original action I filed a long time ago. I've made it farther than that. So
I think it was heroic. I knew how hard you were working over those 5 days to get that thing pounded out, and people.
We tried so hard not to bother you.
It was so
still
hard.
bothered
It was so hard not to like blow you up. What are you doing? Do you need anything? You know, like where are you at?
I messaged her. I was like, "You're probably sleeping." She's like, "No, I'm working." I'm like, "Oh,
yeah.
you should be sleeping."
I knew for a fact she wasn't sleeping. If she's anything like my wife, she was not sleeping.
Yeah, Mark and I had a caseload too, so we were just working in pockets of time, and it wasn't ideal, but we got through it.
All right, babe, read Travis Williamson's question to Cara.
All right, Cara. So we got a ton of people out here that all are super excited you're here, and they all have questions. So like answer for as long as you're willing, and then we've already kept you an hour, so whenever you got to go, you just tell us. But Cara, have you ever seen a gag order that was a minute order as opposed to a clearly detailed order?
You know what? I don't make that big of a. I don't have that big of a problem with the minute order because I read it and I was like, oh, okay. You know, I know what it says. And most people know what a gag order is. No, to me, the minute order, this is fairly normal in Indiana. Sometimes judges will just do a minute entry, and it has the same weight. I read the gag order. I questioned whether you can gag people who aren't parties to the cause, but otherwise, I think the parties understood that they weren't supposed to talk to the press. Now, whether they understood the rest of it, that it seemed like everybody was interpreting it much broader than it really was. But I didn't see a problem with the minute entry. No.
All right. We got Lily Jewell.
Wait, but is it unusual for family members to be included in a gag order?
I've not seen that. And, of course, that was the question. I don't know the answer to that. If you can gag people that aren't parties to the action, obviously the family members have complied as far as I can tell. Of course, also, what's a family member? Is a grandma? Is a cousin? That I don't know. I do know that I think that one of the family members is pretty active on Facebook. I've seen a few, I think, wasn't it Court TV or somebody last night put up some Facebook posts. Does that violate the gag order? Should she even be under it? That's the thing. It was vague, but
that was Travis's point in terms of should she have fleshed it out a little bit. All right, go ahead, read that one, Allie.
All right, Lily Jewell. Your blog says number 1, courtroom are open up to cameras, and number 2, attorney requests to quote listen to transcripts are available. Why hasn't this happened in this case? Is it just Gull?
Number 1, courtrooms. Yes, we're allowing them in. We're allowing cameras in, but it's completely judicial discretion. So is it just Gull? No. I know other judges that do not want cameras in the courtroom. And, I know we all want to see this trial, but could you imagine this? I heard it was kind of a circus on the 19th. It looked like a football game tailgating. So I can only imagine, if I were the judge, I'd want to be like, I don't want to mess with all this. Having cameras on different angles, all of that. So number 2, the listen to transcripts. That's true. It's a court rule that you're allowed to go in and listen to audio, but it doesn't start until January 1st. I actually said that to the court reporter. Hey, did you know starting January 1st, we get to listen to the audio? And she says, well, we haven't adopted that early yet. So January 1st, you can ask to hear the audio.
I'm surprised she didn't send that back as the answer.
Well, because I think she was telling you about the transcript. She was answering on that.
Right.
Either way.
We were trying to schedule an appointment to physically come in and listen. We didn't want any copies of anything. We didn't want you to send a transcript of anything, like physically go in and listen to the recording. And when Gull emailed back at like 6 o'clock in the morning, I was like, oh my God, wake up. Like Gull herself emailed us back. I said, should I ask her like what rule she's using to do? He's like, yeah, ask her that. So I do. And she didn't reply. And I'm like, shouldn't she have been ready to answer this question when she told me that we couldn't listen to it? And then today I sent like a follow-up email. I was like, I'm sure my email was accidentally overlooked, but I'm just wondering if maybe you figured out why we can't go listen to it yet. And she didn't answer. So if what you just said it would have been as simple as replying and saying, it's a new rule. Isn't she an administrative judge there? So she's part of making these rules about the docket and stuff. Like,
I had heard she's on a committee. I hadn't looked into that. Yeah. But that's the other thing is I think you would run into the same problem is if you would have asked, then eventually it would have been, it's confidential. And I think that's how the judge responded, but that's what I was getting from the court reporter. Yeah. And keep in mind, I handle appeals that are completely confidential, that nobody's allowed in the courtroom and except the parties. And what we do in those cases, we file them. And if there's a confidential portion of a transcript in a public case, then there's a separate transcript. So again, they could have said, hey, we'll give it to you, but it's confidential. They could have somehow said it should be marked confidential and we could include it in our record confidentially, but I saw no grounds for it to be confidential.
But you're the party, so even if
and
it was confidential.
Yeah. The parties always, in cases that I've handled on appeal where portions of the record are sealed, the parties' lawyers still get that access to that record, but it's just sort of handled and treated differently. And it sounds like that's what you're used to as well.
Yeah.
So will his new attorneys not get to see? Like, that's what I mean. Like, is it only the attorneys that were physically present? Like, to say that you're representing him, to say that you're not a party, then is his new attorneys not a party either? Have they seen the transcript?
I hope that they're getting to see it if they're, or listen to it. I don't know. I mean, they're for the same reason that they can, I should be able to, but I don't know. My guess is they may not see any reason to listen to it,
And then I wanted her to put back up the last question because we actually didn't get to it. But while she's doing that, one question and one issue that I had is could it be, as far as preserving his appellate rights on specifically the issue of his right to counsel of choice on his private counsel, meaning their appearance, or his right to continuing the continuing counsel of choice. If he does not file an interlocutory appeal, will this original action preserve that error or argument in the exact same way? Because in my mind, I'm thinking it might not be treated the same.
If I understand, depends on what they end up doing. If they issue like a full blown, opinion or order or whatever, my guess is if they deny it on the merits, then it will have been decided. And so it will be res judicata. You're not going to be able to bring it up again. And honestly, in order to be brought up again, his new attorneys would probably have to assert it. And I don't see them doing that.
Right.
And it's our hope that he will write a letter to the court and to his PD demanding that they file or seek to file or try to file, whatever, an interlocutory appeal. But let's turn to Matt Thomas's question. Have there been any other cases of defense attorneys being DQ'd in Indiana for reasons other than not being barred? Thanks.
In the appellate opinions, we found one where the attorneys had actually sort of created this Hobson's choice for the judge and said, either you exclude this DNA evidence or whatever, or we're going to withdraw. And the defendant was not happy with their representation and wanted them withdrawn anyway. And so in that case, they were allowed to be DQ'd, and the court said, you asked for it. This is what you wanted anyway. That was really about the only one we could find. People not being members of the bar. I've never seen that happen before. But other than that, actual conflicts of interest that you can't waive are the only other situation, but nothing like what happened here. No.
And as to Janie Lee's question that will Rick Allen have his motion for a speedy trial granted, it's my understanding that motion was never filed and the new lawyers have not filed it. So
here's what I understood. They got it signed in August and we're holding it until it would be 70 days before that January 8th date. And then if they filed it then, he takes priority over pretty much everybody else that's been, because nobody's probably been in jail as long as he has. So it puts you on the top of the list for priority. So it locks it in, essentially.
Now, is in Indiana, is it is it true that that would be one of the decisions a defendant gets to make, whether or not to assert his right to a speedy trial?
I mean, he does. Yes, he technically does. And when a defendant files that, here's what sometimes happens though, is the defendant will tell his attorney, I want a speedy trial. And the attorney will say, I'm not going to file it for you. And they don't file it. And so that does happen. But if you, I've seen cases where the defendant at the initial hearing, I want my fast and speedy, and the judge will set the hearing and or the trial, and they go.
So, and just to clarify for everyone listening and watching, there are certain things that it's up to the lawyer speaks for the defendant. It's their decision to make, and the defendant huff, puff, scream, yell, this is strategy, this is X, Y, and Z. It's your lawyer's decision to make. The question that I just asked Cara was, is the right to a speedy trial, whether or not to demand a speedy trial, one of the rights recognized in Indiana as being something the defendant himself has the decision to make or not make? And your answer was yes, but you see it be ignored oftentimes.
Now, let's pretend that we fast forward a month and his attorneys they don't want a speedy trial. And he says, I want you to file one. They say, no, we're not going to. We can't be ready. We'll be ineffective if we go so quickly. If he tries to file it on his own, he's represented by counsel, and it's going to be stricken because it's a pro se pleading, or it could be, let me say it that way. And so I've seen that happen in cases, and it's really hard to challenge that because there is a good argument. I mean, I don't know that he would want to go to trial with the new lawyers in just a couple of months. They're not going to be ready.
Right.
So,
Right. All right. Let's go to the art of deduction here.
Question, Cara, could the reason why the transcripts are not released be because of national security due to a certain individual being in active military?
well, that's not one of the exceptions to public access under our rules. So no, but even then, if there's something sensitive information that should be confidential, you just redact that person's name or that information. I assume I know who you're talking about, but I only know because like it's all over Twitter. So, I don't know how confidential it is anymore.
Yeah.
I also don't know that meeting was like, I don't think I'm not picturing a majority of that meeting being about specifically the leak. I see it as being your behavior kind of thing.
Right.
All right. We've got a tornado artist. Cara, what about the amicus brief? Do you call it amicus, or you
I call it amicus because I took Latin in high school.
Okay, so what about the amicus brief from Indiana Public Defender Counsel? How will that affect this writ? And I'm going to put an end on that. Do you expect one from the regular defense bar?
I have an and too, whenever you answer those two ends.
So the Indiana Public Defender Council is kind of like our defense bar, our public defender bar.
Right.
And so I think will only help us maybe alert the court to how important we think that this is, because they did a really good job of explaining not only you got to have this independence between the judiciary and the defense bar. We have kind of this weird messed up way of doing public defense in Indiana. It's a mishmash. We've got 92 different ways of doing it, 92 different counties. And so we have some general guidelines, and they really pointed out those guidelines, and you have to follow them. And if you don't, you can, risk losing some of your funding. Plus, they're pulling a chief PD from his office. I mean, he's got to, do other things on this case. That's going to be something for the Allen County people that they're going to have to deal with.
And the reason that I asked, and I know you got a follow-up there too, Sleuthy, is just that I perused it. I did not get through it by any stretch, but it seemed to focus a lot on, and I was assuming because it was the PD's, the Public Defender Council, the continuing right of the public defender to stay on, that he has a right to that continuing public defender.
Right.
And I still think there's a very, very strong, more cut and dry argument of his right to counsel of choice on his private counsel, meaning when they entered privately. Have you, or does anyone expect to ask any other defense organization that's not specifically public defender whether they have an interest in doing an amicus brief, or have you heard of any other people out there thinking about it?
You know, we haven't really reached out to anybody else, and part of the reason is because we decided, yes, we thought private counsel, that would be even a bigger, right. But when we got into looking at things, it really isn't. And part of it's because before they're appointed, Rick doesn't get to pick his counsel. The judge gets to. But once they're appointed, that is his attorney. And as long as he's happy with them, that's his counsel of choice. And I even think that them, when they were removed, them filing their pro bono appearance made that more obvious, not less. Right. And we decided we didn't want this distinction between private and public defender. And so we didn't highlight that at all.
And before we go to the next one, Sleuthy, did you have an end?
Yeah, I say amicus, but I'm not a lawyer, but also it sounds better. But people were looking at, so when they realized that it was like a group that wrote that, they were wondering if there's individual attorneys that are writing their own kind of thing. Does that exist, or was it just meant to be one lump of everybody kind of thing?
Well, I guess individual lawyers could have, but generally the public defender counsel, they are there to sort of assist public defenders. They train them, and they're called on sometimes in things like this. We've got also a state public defender. They do post-conviction cases, but they also have this weird little thing that they do where if you're a trial court judge and you can't find competent counsel or qualified counsel in your county, you can actually ask for the state public defender to find somebody. She has a list. And so those are the ways that you can, that was what the PD counsel's argument was. That's the process that should have been followed. And again, it's nothing against those public defenders, but what was the public perception is that the local attorneys were the ones being appointed. I would avoid that if possible.
Yeah, I think that it seemed like it left, without making an outright accusation about it, I think it left a good place to kind of see what the response will be. And then if needed, it's like, well, the reason that they're here and the reason they say this and why, let's say someone says, well, that's how they should do it, but that's not what's required, right? They're not, right. She's not required to have them choose who's going to be his new public defenders. Well, an argument could be made that the reason why she should have was because of this relationship, it appears, with one who is the lead in that county. So I felt like it made a good point in terms of why they separate the attorneys from the judges so that this wouldn't happen. Because you can't say, well, she chose her friend, which we can say now, because that's what it looks like.
And, I was more thinking like the National Association of Criminal Defense Lawyers or even the ACLU. And I know there are ways to kind of petition by way of like request, like, hey, let me bring this case to your attention. Do you want to file an amicus brief? Just because I'm used to calling it that way.
Do you want to file an amicus brief?
The National Association of Criminal Defense Lawyers, their strike force was contacted, but as far as I know, they gave some good advice, but I don't know that they would actually get in the weeds with this too much, because I guess, you were just saying that there's a process for attorneys that get disqualified in Illinois. I mean, it sounds like it's not all that unusual in other states, but this is just, it's not usual at all here in Indiana. Usually it's the defendant wanting his attorney kicked off. You almost never see it this way. So that's why I think we were just all sort of surprised.
All right. Now, finally, criminality. Go ahead.
And I love T. I'm so sorry, T. But having said that, it's that rare. But I'm sure you did see the one where Gull herself, she's done this before. Okay. And she kicked that person, if, from what I understand, was he private counsel?
I think so. And I don't think that he didn't do anything after being kicked off, as far as I know, to challenge it. And so,
I don't think he did, but it did come after he asked her multiple times to recuse herself. I think it was like he put like 2 filings in, and then she disqualified him and said that he was too busy and essentially not experienced enough. And that, but again, it like plays in my head. Like if I'm looking back at retaliatory looking things, it does. I'm sorry. That's what it looks like. It looks.
this is the problem. It's the percent. That was our argument. It's
Correct.
the appearance of a bias. That's the standard you have to meet. Yeah.
It's strong, I think.
It is strong. All right. So our friend Teresa from Criminality, great pod or great
Love
YouTube
tape.
channel. She's great. Cara, is it possible that Gull doesn't get removed, but is forced to follow the proper procedures to pick new attorneys, or are Scremin and Libretto locked in?
I think it's possible she does not get removed. She's very well respected in the state, and she's a longtime judge, was prosecutor before that. So that wouldn't surprise me if she stays on. Now, what would happen if she did? If they put Andy and Brad back on, I don't know. Are Mr. Libretto and Scremin locked in?
Can Alan ask to have them removed? Like, can he ask for new public defenders? Like Sarah Boone in Florida, she's on like her seventh.
But again, it would be totally the judge's discretion to give it to him or not. My guess is I wouldn't be surprised if he loses and everything, like Andy and Brad aren't allowed back on. I wouldn't be surprised if somebody doesn't step up and agree to represent him. Because at that point,
outside.
Where's the prejudice to him now? He's already having to start over. I could see new attorneys stepping up and saying, you know what, we're gonna do this one.
Could it be someone that knows Baldwin, or does there have to be like a separation? Could she, if it was someone else in his practice, let's say, could she say?
I don't think it has to be a separation at all. It's kind of interesting because the new attorneys are in a heck of a pickle, aren't they? I mean, they aren't caught up to speed on the case because they just got the information. But if they don't like the defense that's been put forth and they withdraw it, is that going to hurt? Is that going to harm Rick's opportunity? Because now it's looking like he's just making up excuses, right?
Yeah.
Trying to come up with something that sticks. But if they go forward with it, maybe they don't think it's the strongest defense, or maybe they don't think it's supported or whatever. They're kind of in this pickle where I wouldn't have wanted to take this case.
To go forward, they have to consume a lot of information to go forward. It took them a year to consume all that information.
And they're almost locked in because if they try to pivot to a different defense, it's not gonna be a good idea,
I mean, how does that play to the public if they pivot? I mean, the cat's out of the bag in terms of
it plays like their removal did, right? I mean, a lot of people on the 19th said, "Oh, she removed them because their defense was crap. They were lying." Right? Well, that's what I have people tell me.
Brad called her out on it, like in court, like not on the 19th, but on the 31st when he had her, he said,
Tennessee.
he's like, you didn't like the memo. She said, I didn't say anything about the memo. I never mentioned the memo. When did I talk about the memo? She got super defensive.
If you'd give us the transcript, we could tell you exactly when you said something about the memo.
Right. All right. So Richard Plunkett, he's been hitting me on Twitter with this exact question. And Cara, do you know about the Indiana rule of trial procedure 3.1H governing how attorneys withdraw from representing their clients? And there's typically only two ways, right? If you're not barred in the state. Are you familiar with that rule?
Yeah, he's referring to, it usually has to be in writing, and you have to give your client notice that you're going to do it. And it makes complete sense why, because you want them to have enough time to be able to find new counsel so you don't prejudice them.
So his point is obviously, how the hell did these lawyers withdraw when they didn't follow the procedures of this 3.1H?
Mm-hmm. In my opinion, when she removed them, disqualified them on the 31st, that sort of made that issue on the 19th somewhat moot at that point, because I think, even whether they were withdrawn or should have, or they had to file something, at that point, the disqualification would have trumped that anyway. Because really, even if they had withdrawn, fine, on the record orally, they entered their appearance. So they were back on the case technically, but the disqualification, that's why there had to be a disqualification to get them removed.
Right. John. So John Lubers wants to know if you have any experience with the new attorneys. And I'd also follow that up with, and have you done any appeals that involved Judge Gull?
I've done appeals that, well, I've not appealed from Judge Gull. I actually read a record when she was a prosecutor and long time ago. And, you know, she was a good prosecutor, and you can imagine, right? You can see her being pretty feisty in the courtroom as a prosecutor. So otherwise, I don't do a lot of Allen County work. They have public defenders that do appeals. I take appeals from counties that can't find attorneys to do appeals or don't have a large agency. Allen County is pretty big, and so I don't have a lot of interaction with them. So I didn't know these two attorneys at all.
Okay.
All right. So Cara, you have to read this question yourself because
I say voir dire, but I used to say voir dire.
It's technically voir dire.
Yeah,
Oh,
it's a mess.
Wait, but we didn't do the question, Carly. We just put it back up.
well, no, he said she had to pronounce it, and it was.
Oh, that was
proof
the question.
to 1,000 people that no two lawyers say voir dire.
I usually say jury selection and get out of saying it altogether.
Right.
All right.
I was
gonna say, I just-
here.
Okay, let's see. All right, what do we got? Can you comment on the fact that the AG chose not to represent the judge?
I don't really know how that process works. My guess is if they say we're not going to represent you, she can get outside counsel. I don't know who pays for it. I don't know if the Attorney General pays for it. The Attorney General's office, they get private counsel on a lot of stuff at times, and it may just be more of they may be looking for somebody that's more, I don't know, more specialized in that area or something. I don't know. The attorney that she selected, he's a good attorney. So
I've thought about
there's not
this.
going to be shenanigans.
If so the Attorney General's office has already been involved in this case because they represented
The
Westville.
state.
Yeah. And so,
right.
and what's interesting is I want to say it was after you filed. I don't have the exact date on me, but I believe it was after you filed. All of a sudden there was a withdrawal, and it was the attorneys for the Department of Corrections. So I wonder if they couldn't because it would be some type of conflict since they were already on the case.
Or, I wonder if they were getting the notices of everything filed in the trial court and were tired of it and just withdrew. It could be that, but they're pretty good about being able to sort of Chinese wall where they can separate their different divisions, and somebody working on one thing doesn't know what somebody else is doing. So I didn't really take too much from the Attorney General not representing. And they did say when they contacted me about the second one that they hadn't decided yet if they were going to file their own response on behalf of the prosecutor.
So is part of either of your two original actions deal with getting him moved from the prison to a jail?
No, because honestly, completely in the discretion of the trial court, really, and really almost the sheriff. The sheriff is given pretty broad discretion to decide where the best place is. And I think her order after the first transfer was kind of tweaked a bit. She said the DOC could move him wherever his needs required or something, which they would have been permitted probably to do that anyway. But a lot of times, there's not a lot of control that the judges have over the DOC once he's committed over there.
So that leads over to this, the question here, is there anyone who can petition? And that person's thinking also about possibly the ACLU regarding the fact that this man's human rights are being violated since he's being held in prison, even though he is presumed innocent. Based on what you said, is there any type of petition or action or anything that anyone could do in that regard?
I mean, the ACLU or a civil rights attorney could try to. I think Brad and Andy did the best that they could to try to. It's interesting because I made a comment that it's. I don't know if it's. Obviously he's lost so much weight that almost might end up hurting the state's case a bit, because if they're going to trial on the theory that he was the lone killer and did all of this stuff within, a short amount of time. I mean, he's looking like a pretty frail man right now. That may not play well. The jury may be looking at him like, that would be pretty tough for this guy here to have done that. So
Andy's 5'4". He's very small.
I can't tell how tall he is. Yeah. So
he's very
yeah,
little. He's
I
a very
mean,
small guy.
you know, the longer this goes, that may not be a good thing for the state. They may be dealing with that, where you've got a defendant that doesn't look like he's capable of doing it.
All right,
I
and
mean,
we've got
I
Mike
feel like-
Hoffman. Go ahead. Sorry, Sleuthy.
I feel like they don't anticipate that. To be honest, I'm just being totally honest. I don't feel like they anticipate. I don't think that we're thinking about what he's going to look like at trial. I feel. I don't think that they're worried about that. So, but I wanted to ask you before we get too far, because I got multiple messages because I forgot. Can you clarify, once you file with the Supreme Court, so now that they've responded, they put in an order saying you have to file your briefs at such and such a date, are they absolutely going to hear these things? Like, is that guaranteed now?
Like an oral argument or something?
Well,
Or that
just
they're going to
like
consider it
under
at all.
consideration,
Right.
period.
No, they could deny it. They could deny it. Yeah.
Okay.
I think we've made it past the first hurdle of the Chief Justice just denying it outright, like sort of a
Right.
summary denial. I think we've
Right.
made it past that hurdle, but no, they could deny it. Yeah.
But with that being said, the fact that they didn't summarily dismiss it, they
Yeah.
are going to consider it.
From what I understand, the
Yeah.
full court, it'll go to the full court for consideration. Yeah.
Okay,
Yeah.
that's kind of what I was asking
That's what
was,
we're
are they
asking.
even going to go through it all and read it, or could it still be like one
Right.
person reads it and says, "I'll forget it, this is nothing," and then it goes?
That's my understanding is no, we've made it past that hurdle. And
Good.
so we'll see, you know, what the response is, right?
Well, then you're 2 for 2.
And
Oh,
then
I
we've
don't know
got
about
Mike Hoffman.
that.
Then we've
All right,
got Mike Hoffman, and as Bob said, we'll let you go whenever you are ready. So just, give
Oh,
us
yeah.
You'll have to say you're ready,
More
because
minutes. Okay.
otherwise you're
Yeah,
stuck.
I mean, in other words, the people
Is this
keep
how
asking
you make
questions.
money on these super stickers and questions? That's right.
All right. So Mike asked,
ahead.
in the event of a removal of Gull, what is the process of appointing a new judge? Can judges stand up and request to be put on the case? Thanks.
If I understand right, it would be the Supreme Court and it would be the particular justice that's that sort of oversees that district, which I had someone tell me they thought was the Chief Justice. So she would probably be the one that would maybe send out some feelers to judges and see, you know, with the size of this case, I really feel like we have senior judges in Indiana that are retired or they serve part-time. It would be ideal for a senior judge just because this person, I mean, you know, in Judge Gull's defense, she's got a docket also of other cases. To have to try to do all of this it's a lot to ask. So maybe having a senior judge that has a lighter docket.
And
Mike, I'm
Angela's
glad
got
you
a
said that.
question about the Lake County attorneys. Are you familiar with the Lake County attorneys?
Yeah, but in what context? Just how I feel about them, or
Yeah, she said she voted yesterday. She's never missed an election since she turned 18, and she'd love to hear your opinion. So I guess generally.
well, I am on a committee with Bernie Carter, who is her prosecutor, and he's a very nice man. He's been up there for a long time. I don't know too much about the attorneys up there. They again have their own appellate division, so they do their own appeals. So I've done a couple PCRs up there, and that's about all I've done in Lake County. But I did read a fascinating book about Lake County. We had a 15-year-old girl that was put on Indiana's death row a long time ago, and it was from Lake County. And so it was a great backstory of the Lake County politics in Gary, Indiana, and all that. So that was a lot of fun. That's about the extent of my knowledge.
So Anthony SK says specifically to Cara, what is the difference between Court TV in December 22nd saying they had crime scene photos from law enforcement and then the same photos being released by the defense in 2023? What's the difference in negligence?
You know, I don't know because I haven't seen either sets of photos. Are they the same? Have you guys seen
People
that?
say they're the same. I never saw, like, that was the thing. I call the second leak a drip because it didn't really make it out to the public. You know, it seemed like it was mitigated pretty quickly. So, but from what I've heard, yeah, they're the same crime scene photos. That's what I've heard.
then that tells me something got leaked earlier, right?
Right.
And you would think it would have had to have come from law enforcement, because I don't even know if defense counsel had it yet.
Exactly.
They've just been put on the case.
Right. Exactly.
I mean, that's the thing. We sort of accepted, let's assume the leak happened. We know nobody's saying it was like they intended for it to leak, but let's just say it happened. Is that enough to be disqualifying? No, it just isn't. Maybe you get some sanctions from it. They offered up a sanction, which I thought was a pretty harsh sanction. 24 hours is quite a bit. It's $2,400, I guess, if they're getting paid $100 an hour. So
keeping in mind that's working hours, correct? Not like, okay,
I
24
read
hours
that as billable. Yep, I read that as billable hours.
Yeah, that's the way I read it as well.
Yeah.
Like but like the other side of this, they have it as the most grave injustice that's ever happened in the entire world. They're ringing the pathos of, these two beautiful girls brutally murdered, have made it out to the world at large. I mean, that's that camp is putting it in terms like that. And, I just try to explain to people in terms of what a private criminal attorney's law office is like in a case like this, where you're going to have a war room and you're not going to lock the door behind you every time you walk out of that war room.
Right.
And you don't have strangers walking around in there. This guy was a friend of his. He was a longtime friend of his. It was a total betrayal. I mean, because originally there was rumors, which is another reason there should have just been Gull should have had a hearing just to get it all out there. It was her choice. She, it wasn't Brad and Andy's choice to go to hearing, or not really. If she would have said, we're having the hearing, you know what I mean? Like, I need to make a record of this. I want it all out on the record. I want to hear what the cops found out. Boom. Because when people were saying that the intimating that Andy had done it in order to get, there was a theory that he had leaked them to somebody in order for them to bolster the Odin theory, because it would have shown that. And I'm like, Alice and I were trying to explain to people, like, no defense attorney ever wants pictures of victims going out to the public. It kills their client's case, So yeah, I don't know.
So Cara, is there anything else that you would want to say, or thoughts, feelings, anything that you want to share or discuss?
I guess the only thing I would say is, a lot of people are really upset with the judge, and I understand, but I guess I'm an appellate lawyer, so I see trial judges, they're the first level. And if they say no, I always think, well, they're not the last word. Right. And so I never really take these things personally. I don't look at the judge as being, I've heard people using a lot, she's evil or what. None of that. I don't see it that way. I think, it's just a decision being made, and it's a decision that we think was the wrong one. We're trying to fight it. And, this isn't personal or anything like that. But
yeah, I feel the same way. There's no part of me that thinks that she's part of some big conspiracy to convict Rick. That's not the thing. I don't think that she's evil. I think that she made a really bad decision with respect to this. I think that she might have got sucked up into what was going on with all of it, in terms of, but I don't know the politics of Carroll County, and I don't know that she has to deal with that anyway, because she's in Allen County. It's not her county. I don't know that Carroll County would have the reach to get to her in terms of kind of applying pressure, like, we want to get rid of these guys, because when she asked McClelland in open court, without the benefit of there being a hearing, and McClelland turns around and says, oh yeah, I agree with Your Honor that they're grossly negligent.
Bizarre.
They
lied.
It was strange, and then starts throwing out there that they had lied. It's a very strange circumstance, the whole thing, that just kind of.
I don't see anybody putting pressure on Judge Gull. I just know she's not easily intimidated by people.
I agree.
I can give you, so as a member of the public, just a normal ass person in the public, you guys are obviously going to look at it different than I am. The way that I'm looking at it, I'm looking at it as like, not so much that someone's forcing her to make these decisions, but just that it is, I want to say a wrong decision, but there must be a better word than that. She's making this decision, and I just get concerned how many other decisions where everybody wasn't watching might have been like this that weren't necessarily fair, or let's say it all gets overturned and it's not correct. And they're like, you can't do that, dude. Why'd you do that? How many other times did you do that when you weren't allowed to do it? That's my concern, is what's happening to people every day. That's my concern.
I can, that's what I kind of love about the fact that these cases are actually, out in the public and you can watch court TV and all of that and Law and Crime, whatever, is because, people who are in the courtroom every day, we see stuff happening. We're like, I can't believe this is happening, and then sometimes in order to fix it, you've got to shine light on it. And that's the thing, is it's good that people are seeing, there's a lot of injustice out there. And it's not just one judge or anything like that. Sometimes it's coming from public defenders or defense attorneys that aren't doing a good job, prosecutors that are withholding, exculpatory evidence. It's coming from a lot of different ways. Yeah. So if anything, I hope people understand that sometimes when somebody says, hey, they did me wrong or whatever, they might have actually been done wrong,
So before we let you go, Cara, I want to put up at least a couple of comments of people so you can get your accolades here. So
everybody loves you. I get messages all day long about
big fans.
So Charmaine says, from Charmaine and Senny, thanks for joining us last night, Bob. And Cara, what can we say but thank you? And obviously, Sleuthy and I rock.
Thank you.
So thank you.
No, she said,
thank you.
She didn't read it right. They said you're an absolute rock star, and Molly and Sleuthy rocked it.
She's an absolute rock star. Okay, so
right,
sorry.
right.
You're right.
I mean, they did inappropriately stick the exclamation points before it, so it was confusing.
It's all right.
So,
my God.
So the unraveling, the Calvary has arrived. Cara, from the bottom of our hearts, thank you for your commitment to justice and brilliant work on this case. You have a forever friend in us, and every ounce of our gratitude. So
thank you very much.
Thank you.
Very nice.
Same. I feel the same.
I think all of us do. Like we could keep you on here forever. We've already kept you on for an hour and 40 minutes. You've been so gracious with your time, and you've answered everything. I'm so thankful for what you do, for what you've done in this case. And like you said, I mean, at the end of the day, it's shining light, and that's my big thing on this, is that we have to shine light. I think you and I talked a little bit about it. I think if this doesn't go our way, I think Brad and Andy are probably done. I don't know that there's any further things that they can do. I think that we'll have to lick our wounds and hope for the best for Rick. And, I hope that something, I hope your prediction that somebody else, some other knight in shining armor comes in, or knightress. Knight has no gender. It could be whatever. Just another attorney comes in and says, you know what? I'm up for it. I'm game, and it's a huge ask. A case like this it's a practice killer. And, so, I mean, it would be a massive give, but, I tend to agree with you. I think that there's probably a couple people out there that would be willing to do it. If I was licensed in Illinois, I'd probably be trying to talk else.
Indiana.
Yeah, I'm in Indiana.
So essentially, if we don't
she'd
win,
be telling me, "Are you nuts?
Win.
We already did this. We're not doing it again." We took a massive beating on that one. So, so thank you so much for joining us. You've been amazing. What a wonderful guest. We all bow to your brilliance and your fortitude for getting that done in such a short period of time. And we're all rooting for you and the fellas. So
ditto.
You're the best. You're the best, Cara. Thank you.
It was great. I thank you for having me.
Always. You got a home here anytime you want to jump up.
All right, guys.
Everyone.
All right. Take care.
And
all right,
we'll still
awesome.
stay here.
Yeah, I gotta go. I gotta get like Sleuthy. You don't have to stay for the shout outs, but I gotta give them to all the peoples. You can. If you
I'll go. I never did carry him. He woke up right. I said to you, I'm going to bring him to bed in 5 minutes. And then immediately his eyes opened, like his soul felt me say that. And I'm like, what are you doing? Any other day you would be dead asleep by now. And he's like, oh, I'm watching YouTube. And so he did finally fall back asleep. So I'm going to carry him. Thanks
All
for
right.
having me on. She's awesome. You guys are
course.
awesome. Allie, I'm
Thanks.
so glad I got to see you.
All right. Thanks, Sleuth.
Bye.
See ya.
All right, so start with this one.
All right. Persephone Applewood, $10 holla. Finally have a bit to share, and I knew it had to go here. I love you guys so damn much. Thank you for being awesome. No, thank you.
Thank
Thank
you.
you for saving up cash and giving it to us, because we really, really appreciate it. Spicy
All right,
Cappy.
YouTube member.
We love that. We love that. Wait till you see some. We got a couple of big ones. Patricia Peterson. This is for Allie. Last time when Bob made you blush about how you drink water on the exercise bike, were you complimented or upset? A chat member said upset. I said complimented.
Complimented.
Yeah, I was saying how
Bob
cute
makes me
you were.
blush all the time.
I thought I was saying how adorable you were when you're doing it. Chelsea, thank you so much for joining the family. DGRJ, is that DGR? I'm so blind. Dave, thank you for becoming a member, man. We appreciate you. Nav Theo, and this, so like Nav, thank you for becoming a member. But what do you see what Nav did next? Laura Smart, thank you so much. We love having you. Thanks for being here. Laura, wait till you see what she did next. Like,
wow. All right.
Boom. Nav 50 memberships is like, wow. Thank you, Nav. That
Very
is
generous.
above and beyond. That's incredible. Thank you for helping us build that community.
Where we are the cosmic dust. All
yes.
right.
We love it.
that handle.
Love that cosmic. Charmaine, as always giving it till it hurts. 5 Defense Diary memberships. Laura K, thank you so much for joining the team. We love you. Kristen
Super
Beck,
sticker.
Dollar Holla. Love it. Thank you so much.
Thank you.
Criminality, Teresa, you're the best, baby. Love it. $10 Defense Diaries. Janie Lane, 5 Defense Diary podcast memberships. Thank you so much. Thank you.
All right.
Boom. Laura with another 50.
She's pretty smart.
Memberships. Super smart. Thank you. Thank you so much, Laura. Tom JR. Thank you for joining the fam, man. We love having you here. Appreciate it. Lorna Dune. Thank you for joining the team. We love it. We love it. And when we say we love it, we really do love it.
We do love it.
Tiffany Tracy, thank you so much for becoming a member. And we hope we're giving you all content, that you guys are enjoying. And I wanted to say, I read the comments. Allison's like, why are you reading the comments? I like to read the comments because I like to see what you all have to say. And look, we've been together 20 plus years, when you're watching a husband and wife, you're going to see some of the real Bob and Allison, like, because we are who we are. So try not to be so hard on us if we go at each other a little. I never feel like Allison's cutting me off. I never feel like Allison's yelling at me. I never feel like she's like, that's how we operate. And we are madly in love with each other and we respect the hell out of each other. So while we appreciate the comments for concerns for either of us, trust us, we're all good. Believe me when I tell you.
Jennifer Johnson.
Jennifer Johnson,
Also
thank you
gifting
so
some
much. All the
memberships.
gifting. I mean, we are entering the season of giving. It's an amazing time of year. Lisa Lang, the $5 holla.
She's done a bunch of.
She's amazing. She's amazing. We got usual suspects that just give till it hurts. True Crime Cafe with Dago. Hey, Paisano. Great panel, great show as always. Thank you guys. No, thank you.
Thank
Dago.
you.
Appreciate you, man. Jedi Platypus. You are amazing.
Can Judge Fran Siegel be removed? I mean, that's the hope. That's
the $1 million question. Who dis? Amy, YouTube member. Welcome, Who dis? You ask great questions too, Who dis? Just so you know that. Joan Bradley, $5 holla. Love this group. Everyone is so informative. Thank you. We try to give you the straight dope, just facts. I had somebody yesterday write a real long comment. They're like, hey, don't talk about law in other states that you don't know the law, because apparently in California, she said they're allowed to the judge is allowed to rule on their own disqualification. So I then went to go try to look up the law. It seems impossible.
No, it doesn't seem
I think that there's situations where a judge, where they're given a motion for recusal,
right,
where you're saying that there's a conflict,
And it's
that
the
judge
judge's
has to
call.
handle that. But in terms of disqualification, I'm going to disagree on it. I'm going to look up the law and see if that's
California. We will acknowledge California has a very different set of common laws. They have their own.
Yes, they do.
You can't just pop into California. It's very different there. New York, same thing.
Yep.
Louisiana has a whole different thing going on as well. But there are ways where you present the possibility of a conflict to a judge, and it's their decision, and they can say whether or not they believe they have a conflict, and they can rule on it from a conflict point of view. But if you're asking that they actually be disqualified, that they are prejudiced against the defendant and the counsel, that would be a surprise if the judge that you're arguing is prejudiced is able to decide the issue.
Counterintuitive for sure.
It's counterintuitive. So if it exists, so be it. It's unusual.
Debbie, $3 holla. Thank you,
Thank
Debbie.
you.
Appreciate
A
you.
member and a holler.
Yeah.
All right.
Jen from Modest. Oh, what's up, girl? Member for a month. Thank you for making sense of the meats. This mess. Thank you, Jen from Modest. Love it.
Hope we are.
I missed you. I haven't seen you in a while. Michelle H, member for a month. Thank you so much. Appreciate you. I can't read it. Is it Fabiola? Fabiola Cruz, $2 holla. Thank you, Fabiola. Appreciate you. Babamba became a YouTube member. Boop, boop. Love it. Thank you. Dago's coming back. Great show, guys. Appreciate you both so very much. We appreciate you, man. $10 in.
The True
I'm gonna
Crime
call it a
Cafe.
$10 holla now. I mean, you get the $10 holla. And just so you know, Mandy, one of our amazing mods, and all of our mods are in here, and we thank you guys so much for taking your time, your valuable time, and helping us out with this, everything to us. But she made some amazing emojis. I don't know if there's something that I have to put in there or if they were able to put them in, but they're really cool.
I wanted to put up this Scarlet one because she kept coming in. Well, now she took my phone away from me, asking me questions. I was going to be like, somebody pop a Scarlet emoji up there.
Yeah, they're great. So we'll get that figured out, but they're really cool. And I think that when members can use the emojis, like, when you guys are chatting, and they're pretty neat. We think they're pretty cool. So mods, is that everybody, or we have more? I hope
so, because I'm going to leave you to do them on your own after this. I got to deal with.
I think since the mods have quit putting them up, I think that you're good. All right, babe, you can bounce.
All right. Thank you, everybody. Appreciate everything and all the things and the like. And hopefully we are, like Bob said, giving you content that is helpful, and it seems that way from what everybody is saying. So I'll let you go from here, babe.
Yeah. All right. My king of kings. Why would a judge ask the prosecution why or what they think about the defense behavior? That is frightening. It is. I mean, look, had there been a proper motion filed, it's obvious that the prosecution is going to get to be able to say their piece. To ask just out of the blue, like Gull did with respect to what happened, very unusual. And it was frightening, because I don't know what McClelland was basing his finding of gross negligence on, because there was no hearing. So yeah, I agree. Fofa, I made you a mod, right? I hope I did. I think I did. Wouldn't the judge have had to have finished reading the Franks motion in order for them to have heard in that hearing? Yes, absolutely. There's no way it was going for the Franks hearing. She would have had to made an intermediate or a preliminary finding that there was enough there to go to a hearing. So it's kind of a two-step process. All right, let's see. Yeah, why is the judge? I don't know. I don't know if she is. I don't know if she is. I don't know. I mean, it does have to go from audio, and then they actually have to transcribe it into words. Maybe that takes some time. It does seem like she's avoiding it a bit, but I mean, look, Cara knows better than we do. She's an Indiana lawyer. She doesn't really. She's not thinking there's anything nefarious going on. We'll find out, I guess. I mean, there was somebody had asked the question. If I could find it, I'm going to put it up. It was about, and I think it was Yellow Jacket. She asked, what happens if there is, here it is. What if transcripts don't exist? That's quite a question. I don't know. I mean, she's on record as saying that they do exist. If it turns out that they don't, I think that there's going to be, I mean, that's something that the Supreme Court's going to have to deal with, because today I didn't put it up, but there's the court order came out from the Supreme Court. We talked about it. They gave her the 16th of this month to either produce the transcripts or give them a written response as to why she hasn't produced them yet. All right, let me see what else we got. I hope we got to enough questions, y'all. We weren't asking them while Cara was here until the end, just because we wanted to be able to get her all her knowledge out to y'all. Got some late super stickers. Kelly Hill, $3 holla. Appreciate you. So, I keep clicking it on. Oh my God. I'm gonna go back to Kelly real quick. $3 holla, Kelly Hill. Thank you very, very much. My girl Shay, True Compass podcast episode where I was on with Shay, dropping tomorrow. So make sure you check whatever your podcatcher is and listen to her pod. It's great. She really digs into the stuff that everybody's not talking about. And it's really ethics based, but they're fascinating questions. And she really, digs into some really, really cool areas that aren't just like right there for you in terms of off the top of your head. So she's really putting some thought into it. I highly, highly recommend everybody check that out if you're into pods. And then, Billy. So I don't know if it's ref it or refit, but whatever it is, man, I'm super appreciative. Thank you so much for that $20 holla. You the man. I appreciate it. So, all right, I'm going to call it, y'all. We're just shy of 2 hours. I want to thank all of you for being here and hanging with us for this 2 hour period of time. We hope, as Allie said, that we brought you some quality content. We hope that we got you some answers, because I knew that there were a ton of questions out there. We hope that we asked questions that you wanted to know as well. I know some of it was technically legal, but I think at the same time, we try to break it down so you all can understand what the hell is going on in this case. So, I mean, at this point, we're in a wait and see, I know what I'm rooting for. I hope, obviously, even if Gull's not removed, I hope that Andy and Brad are brought back into the case. I think that's what's in the best interest for the girls, because I think they're most prepared to put forth a valiant effort and try the case properly, which at the end of the day is what we care about. We need a fair trial. So this thing, if it goes through, and whether Richard Allen is guilty or innocent, if they have more evidence and they can make their case, so be it. It is what it is, and if they can't, then we hope that these guys who believe that he's innocent, that they do the job and he's not convicted, which leaves us a bigger nightmare. Are they going to continue to investigate, or does this case just fall apart and go away? It's a scary thing to think about, but it's got to be in the back of all of our minds. So, all right, y'all, thank you so much for hanging, because without y'all, I'd just be an old man talking about an old case. Talk at you next time.